however, with reference to the order passed by the tribunal or the judgments of High Court or the Supreme Court, the contention was that these can be even prior to the order passed by the assessing authority, meaning thereby the assessing authority at the stage of passing of assessment order had ignored certain binding precedents by the tribunal or jurisdictional High Court or Honorable the Supreme Court. There cannot be any dispute in the proposition of law to the extent that if there is any error in the order passed by the assessing authority who failed to take notice of a binding precedent in favor of the revenue, the order being prejudicial to the interest of the state can be revised. However, in those circumstances, it will be the normal period of limitation within which such a power is to be exercised. The exception clause cannot be permitted to be invoked in normal circumstances, as the department had ample time as provided in the provision, namely 3 years from the date of passing of order sought to be revised. If the exception clause is to be invoked, there have to be exceptional circumstances, even if any amendment, order of the tribunal or judgment of the High Court or Honorable the Supreme Court is subsequent to the passing of the order of assessment. In normal circumstances, the exercise of revisional jurisdiction has to be during the period of limitation, except in cases where the amendment or the order judgment on the basis of which revisional jurisdiction is sought to be exercised had come into existence just before the limitation, as provided in Section 34 of the Act, was to expire. Those cases will depend on the facts of each case to be examined as to whether exception clause for exercise of power for revision beyond the period prescribed in that section can be allowed to be invoked or not. However, in the cases where the grounds, namely 3 exceptions as carved out in second proviso to Section 34 of the Act, were available much before even the passing of the order of assessment, the exception clause providing extended period of limitation cannot possibly be permitted in those cases. In case permitted, that would amount to adding premium to inaction, incompetence of the authorities, which is clearly against the spirit of the Act. It cannot be said to be exceptional circumstance if the facts of the present case are considered in the light of enunciation of law referred to above. In my considered opinion, it is a case where the respondent as well as her family should be kept away from the child, as there is every likelihood of their poisoning the mind of the child against the family of his deceased father. Once a girl is married and she moves on to her matrimonial home, she belongs to that family.